Welcome back to our lecture series on the law on sales. In our last lecture, we discussed the concept of a contract of sale under Article 1458. Today, we move forward to a crucial set of provisions, Articles 1459 to 1465 of the Civil Code, which focus on the object of a contract of sale. Together, these provisions establish the foundation for determining whether the subject matter of a sale is valid and enforceable. Before we proceed, let us first look at a roadmap of Articles 1459 to 1465 of the Civil Code, which focus on the object of a contract of sale. First, we look at the requisites concerning objects and the kinds of illicit things that cannot be sold. We then consider the right of the vendor to transfer ownership and the rule that the subject matter must be determinate. Next, the law covers sales involving potential existence, hopes or expectancies, and future goods, showing how contracts may deal with things not yet in existence. Finally, we study special provisions on the sale of undivided interests, shares in a mass, and sales subject to a resolutory condition. Together, these articles set clear boundaries on what may be sold, while allowing flexibility for modern commercial practice. Article 1459 provides, the thing must be licit and the vendor must have a right to transfer the ownership thereof at the time it is delivered. This article establishes two essential requisites for the object of a sale. The thing must be licit, and the vendor must have the right to transfer ownership at the time of delivery. First, the object of the sale must be lawful. This means the thing being sold cannot be prohibited by law, or contrary to morals, good customs, public order, or public policy. Examples of illicit objects include illegal drugs, smuggled goods, and stolen property. Since these things are illicit, they cannot be valid objects of a sale. By contrast, licit objects are those that the law allows to be the subject of commerce. The Civil Code recognizes different kinds of licit objects: existing goods, already owned or possessed by the seller; future goods, to be manufactured, raised, or acquired after the perfection of the contract, which we will tackle under Article 1462. Things with potential existence, such as a future harvest of crops, as we will discuss under Article 1461. However, the law makes it clear that the sale of a vain hope or expectancy is void. For example, selling a future harvest is valid because it has potential existence. But selling mere speculation is not. The second requirement under Article 1459 is that the vendor must have the right to transfer ownership at the time of delivery. It is not necessary for the seller to be the owner at the time of the contract's perfection. What matters is that he has the right to transfer ownership when delivery occurs. If the seller is not the owner, or is not authorized to sell at the time of delivery, the sale is void as to the portion he does not own. Article 1460 states, a thing is determinate when it is particularly designated or physically segregated from all others of the same class. The requisite that a thing be determinate is satisfied if at the time the contract is entered into, the thing is capable of being made determinate without the necessity of a new or further agreement between the parties. In short, the law requires that the object must be identifiable, either by specific designation or by the terms of the contract itself. The perfection of a contract of sale requires consent on the object and the price. If the object is not determinate, there is no valid contract of sale. But the law is practical. It does not demand absolute precision at the outset. It is enough that the thing can be identified based on the contract's terms and existing facts, without the need for a new agreement. Consider this example: Joe sells to Bill a 500 square meter portion of my land in Barangay X, to be taken from the northern part. Even if the precise metes and bounds are not specified, the subject matter is determinate. A survey can identify the exact location without requiring a new agreement between the parties. This principle has been consistently affirmed by the Supreme Court. In the case of Camacho v. Court of Appeals, the Supreme Court ruled that the absence of exact boundaries does not void the contract, as long as the portion can still be identified by reference to the agreement and circumstances. This case illustrates the law's flexibility in upholding contracts where the object is sufficiently identifiable. To recap, Article 1460 requires that the object of sale must be determinate. A thing is determinate when it is particularly designated, physically segregated, or at least capable of being made determinate from the contract's terms. Absolute precision is not necessary, only that the thing can be identified without further negotiation. Article 1461 provides, things having a potential existence may be the object of the contract of sale. The efficacy of the sale of a mere hope or expectancy is deemed subject to the condition that the thing will come into existence. The sale of a vain hope or expectancy is void. This provision allows the sale of things with potential existence, meaning items not yet in existence but reasonably expected to come into being. The sale of a mere hope or expectancy is valid but subject to the condition that the thing will come into existence. However, if the hope is vain or impossible, the sale is void. The first category is the sale of things having potential existence. These are objects that do not yet exist at the time of the contract but are reasonably expected to come into being as a natural product or increment of something already owned by the seller. Examples include the future harvest of a rice field, the milk a cow will yield next season, the fruits that a mango tree will bear. In the case of Pickle versus Alonzo, the Supreme Court upheld a contract for the sale of coconuts to be harvested in the future, affirming that the law allows sales of potential products as long as they are tied to something already existing. The second category is the sale of a mere hope or expectancy. Here, the object of the contract is not the thing itself, but the chance or expectation that it will exist. Examples include the catch from a future fishing trip, or the possibility of winning a lottery. The sale is valid but subject to the condition that the thing will come into existence. If the hope is realized, the buyer gets the thing. If not, the contract is not effective. If the hope is vain, or in other words, impossible from the start, the sale is void. Such as an impossible expectation, for example, selling the catch from a lake that has dried up, or the possibility of winning the lottery from an expired lottery ticket. In both examples, the sale is void from the beginning. To apply, suppose Joe sells to Bill all the mangoes that will be harvested from Joe's orchard next season. Separately, Steve sells to John whatever gold may be found in a riverbed that has been scientifically proven to contain no gold. Is the sale to Bill valid? Why or why not? Is the sale to John valid? Why or why not? Pause the video and try to analyze the scenarios using Article 1461 and relevant jurisprudence. Identify the nature of each sale and whether it is valid, void, or subject to a condition. To recap, Article 1461 recognizes the reality that commerce often deals with the future. Sales of things with potential existence are valid, because they are tied to something real and existing. Sales of a mere hope or expectancy are valid, but conditional on the thing coming into existence. Sales based on a vain hope are void, because they involve impossibility from the start. This doctrine balances the freedom of contract with the need to prevent speculative or impossible transactions. Article 1462 provides, the goods which form the subject of a contract of sale may be either existing goods, owned or possessed by the seller, or goods to be manufactured, raised, or acquired by the seller after the perfection of the contract of sale, in this title called future goods. There may be a contract of sale of goods, whose acquisition by the seller depends upon a contingency which may or may not happen. This provision widens the scope of valid sales by allowing contracts not only for present goods but also for those that will come into being later. The first category is existing goods. These are items already owned or possessed by the seller at the time of the contract. For example, selling your car today is a sale of an existing good. The second category is future goods, things that do not yet exist or are not yet owned by the seller, but will be manufactured, raised, or acquired later. For example, a contract to sell the harvest of a rice field before the crops are grown is a sale of future goods. Both types are valid objects of a contract of sale under Article 1462. The law goes further. It recognizes contracts involving future goods, even if their acquisition depends on a contingency. This is common in practice, for instance, pre-selling condominium units, or agricultural products that will be harvested later. However, recall Article 1461, if the object is a vain hope or expectancy, meaning it cannot possibly come into existence, the sale is void. The Supreme Court in a number of cases emphasized that the sale of future goods is valid as long as the thing may possibly exist. Also, the sale is not void even if the seller does not own the thing at perfection, as long as ownership is transferred at delivery. So what does undivided interest mean? It refers to a share or quota in a property that is not physically divided. For example, if 3 siblings inherit a 900 square meter parcel of land, each has an undivided 1/3 interest. This means each owns 1/3 of the whole property, not a specific 300 square meter section with fixed boundaries. Article 1463 of the Civil Code allows the sale of an undivided interest in a thing, meaning a person may sell their share or quota in a property even if it is not physically separated from the whole. In the earlier illustration, 3 siblings, say, Jane, John, and Jenny, co-own a 900 square meter lot, each having a 1/3 undivided interest. Jane may sell his 1/3 share to a third person, Bill. Bill then becomes a co-owner with John and Jenny, but Bill cannot claim a specific 300 square meter portion unless the property is partitioned. If Jane tried to sell a specific 300 square meter portion by metes and bounds without John and Jenny's consent, the sale would not be valid as to that specific portion, but only as to Jane's undivided share. To summarize, Article 1463 permits the sale of an undivided interest in property. The buyer acquires the seller's rights and becomes a co-owner, but the seller cannot unilaterally sell a specific portion by metes and bounds without the consent of all co-owners. Article 1464 provides, in the case of fungible goods, there may be a sale of an undivided share of a specific mass, though the seller purports to sell and the buyer to buy a definite number, weight, or measure of the goods in the mass, and though the number, weight, or measure of the goods in the mass is undetermined. By such a sale the buyer becomes owner in common of such a share of the mass as the number, weight, or measure bought bears to the number, weight, or measure of the mass. If the mass contains less than the number, weight, or measure bought, the buyer becomes the owner of the whole mass and the seller is bound to make good the deficiency from goods of the same kind and quality, unless a contrary intent appears. This means that the buyer acquires a proportional share of the mass, even before the goods are physically separated. Let's break this down into 2 key principles. Undivided co-ownership, the buyer becomes a co-owner of the mass, proportional to what was purchased. For example, if a buyer purchases 30 sacks from a warehouse of 100 sacks, the buyer owns 30% of that mass, even without physical separation. Insufficient mass. If the mass turns out to be less than what was sold, the buyer becomes owner of the entire mass, and the seller must make up the shortage with goods of the same kind and quality, unless the contract says otherwise. Suppose a warehouse contains 100 sacks of rice. The seller sells 30 sacks to the buyer, without separating them. The buyer now owns 30% of the rice in the warehouse as a co-owner. If at delivery there are only 25 sacks remaining, the buyer owns all 25 sacks, and the seller must provide 5 more sacks of the same kind and quality to complete the sale, unless the parties agreed otherwise. This rule protects both buyers and commercial transactions. It ensures that sales of bulk or fungible goods are valid and enforceable even without physical segregation, and it safeguards the buyer's interest if the mass is insufficient at delivery. This is crucial in commerce, where goods are often sold in large quantities by weight, volume, or measure. To summarize, Article 1464 permits the sale of a definite share of a larger mass of fungible goods. The buyer becomes a co-owner in proportion to the quantity bought. If the mass is insufficient, the buyer acquires the whole mass, and the seller must supply the deficiency with goods of the same kind and quality. Article 1465 of the Civil Code provides, things subject to a resolutory condition may be the object of the contract of sale. Recall that a resolutory condition is a future and uncertain event which, if it occurs, extinguishes rights that are already in effect. In the context of sales, this means that the sale is valid and effective from the start, and ownership passes to the buyer upon delivery. However, if the resolutory condition happens, the sale is extinguished, and the ownership reverts to the seller. For example, Joe sells a car to Bill, but the contract states that if Bill fails to pay the balance within 6 months, the sale is automatically rescinded. Here, Bill becomes the owner upon delivery, but if he fails to pay, ownership reverts to Joe. Another example would be a house sale with migration condition. John sells his house to Bob, subject to the condition that if Bob migrates abroad within a year, the sale is rescinded. In this example, if Bob stays, the sale stands. But if Bob migrates, the house reverts to John. To conclude, Article 1465 allows things subject to a resolutory condition to be valid objects of sale. The sale is effective from the start, and ownership passes at delivery. But if the resolutory condition occurs, the sale is extinguished and ownership reverts to the seller.